Assalamualaikum warahmatullahi wabarakatuh. My name is Nur Ali Amira binti Jumain. My metro number is 1232194. So today I would like to explain about the sources of international law. Okay, the first one, basically, this slide outlines the five key sources of international law as recognized in Article 28, Clause 1 of the ICJ Statute, which guide the International Court of Justice in dispute between states. The first one is the treaties. What is treaties? Treaties, the written is agreements between states that creates a binding agreements obligations. Second one is the customary international law. What is the customary? Customary is evolved from generals and consistent state practice combined with opinion juries. The third one is the general principles of law. What is general principles of law? Is a fundamental legal concept common to most national legal systems, such as a good faith, equality, estoppel, or res judicata. The next one is the judicial decisions, which is the past decisions of the court of ICJ or national court that serve as persuasive authority. And the last one of the main source of international law is the writings of publicists, which is the opinions of the leading jurists. For the next slide, I would like to explain about the hierarchy and interactions of sources. So this is the order of a treaty among international law sources. So first one is the just congruence with the primary norms. So this is the highest norms are universally accepted and non-derogables. So no treaty or custom can contradict them. Example, prohibitions of genocide, slavery, tortures, and aggressions. Second is treaties. Treaties is binding on member states, which is that when two states are parties to treaty, is provision that presidents elect specialized delegate legally generally. Okay, next one is the third one. Customary international law, which is applies when no treaty covers the issue, which is applies when no treaty exists or when a state isn't bound by one. So it reflects the general conduct of states accepted as a law. Okay, and this one is the general principles of law, which is this one. This source is to fill in the legal gaps. And the last one is the judicial decisions and juris writings. So these are subsidiary sources. They don't create law, but help to clarify, interpret, and confirm existing rules. So example case that we can relate or we can easily understand to more understand about the source of international law is the case of North Sea continental shelf, which is in the case in the years of 1969. So basically, in this case, the parties is Denmark, Netherlands, and West Germany. So in this case, the issue is whether the equidistance principle in 1958 Geneva Conventions on the continental shelf had become a part of the customary international law, even though Germany has signed the treaty. So in this case, the ICJ rulings, the court held that the principles had not yet crystallized into custom because of what? There was no consistent and widespread state practice and no sufficient opinion juries to believe that states opinion juries that follow it are legal obligations. So a treaty may declare crystallizes or general customary law, but only if there is a broad state acceptance. Another case is the case of Nicaragua against United States in the year of 1986, which is in the case that the background is Nicaraguan they get accused of the U.S. for the U.S. for violating international law by supporting by support rebels and mining harbors. So basically, in this case, the issue is could the ICJ apply customary law even though the US had opted out the treaty based on the jurisdictions of the UN Charter's Article 2+4. So in this case, the court held that the customary provisions on the use of the force of exist independently of the UN Charter, meaning the same rule existed in both treaty and customary form. So in this case, the significance is to demonstrate that treaty law and customary law can exist in parallel. Even if the state withdraws from a treaty, it may still be bound apply the same rule under custom. Alright, next is the importance of understanding the hierarchy of international law. So the first one is help to identify which law apply first. So knowing the order of the sources from just cogents to the subsidiary means guides courts and lawyers on which rule are to apply when different rule exist. For examples, so if a treaty and custom conflict, the treaty, if binding on both parties, take priority. Second, to prevent legal conflicts, which means that the hierarchy helps avoid contradictions between treaties, custom, and other rules. So this ensuring consistencies and fairness in international decisions. So the third one is to protect the fundamental values, which is at the top of the hierarchy are just against norms, rules like prohibiting genocides or slavery, judicial slavery, which is state that can break. So this protects global moral and legal order. The fourth one is to ensure fair decisions making. So when treaties and custom and cover situations, courts can rely on general principles, judicial traditions, and juris writings to fill gaps and reach a fair results. The last one is the practice and the use in the real case. So in the real intention dispute, so the courts first check if there are treaty that binds a party. If not, they look at the customary law. If neither applies, there are general principles of past judgment for guidance. So this method ensures that every case can be resolved using logical, accepted order or legal authority. That's all from me. Thank you.